we're hearing from all quarters today. The idea, of course, is that there's a lot of developments around IP law impacted by artificial intelligence technology. And they're not just happening in the district court in San Francisco and New York. They're happening all over the world. And some jurisdictions are actually deciding, for the first time, some of the first substantive cases in the IP field. So we're starting to see opinions that dig down below the initial level. We're starting to see some more doctrinal opinions about how do you enable a patent that's an invention that's AI assisted. And we're starting to see some decisions on how will we determine patentability in the AI era, what kind of prior art is relevant, et cetera. We're going to talk about all that. But the microcosm is that this conference is put together by 3 different pieces of the Berkeley law world. Berkeley Center for Law and Technology, of course. The course that we teach, Dr. Howe and I, on IP and human creativity is under the BCLT umbrella. And we're in our 3rd year on that course, and it's been really eye-opening for me. The other sponsor, the second of 3, is the Robbins Collection here at UC Berkeley, which, if you were in the world of civil law and canon law scholarship, if you were somebody who needed to see a medieval commentary on Roman law, you would know the Robbins Collection because they have one of the world's great collections of fundamental texts in civil law, in canon law. And we've been looking to partner with them for a long time. My long-term colleague, Laurent Mauny, who's here. Laurent, you want to just give us a wave? Yeah. I've been trying to figure out a way. I respect him a lot, and we've been colleagues for a long time. For a long time, I've been trying to figure out a way for us to do something together. And it turns out that this space is perfect because a lot of developments are happening in many different kinds of jurisdictions, and the civil law focus of the Robbins Collection makes a lot of sense. And then just in talking to him today, he was reminding me that because we take a sort of a human creativity angle, certainly in our course, and we really think about the impact of AI on human creation and the human creative professions, Laurent was reminding me that the birth of humanism was really one of the generative moments in the Renaissance and in late medieval times. Particularly, he was talking about the 14th century. He said that was the first time people really began to think about human creativity and move it out from a purely theological umbrella into a kind of humanist focus. So I think the overlap is even stronger. The last component is we wanted to hear from as many Asian countries as we could because AI technology is taking off very quickly. And so we brought in also the Korea Law Center at the law school to help us fund some people to come in from Korea. We have, today we have Judge Kim from Seoul, and we have a number of Korean practitioners who are here. And we're very happy about that because, as I say, AI technology is really popping up everywhere. And we don't want to limit our focus to the handful of US cases, which so far, as you know, are clustering around copyright, in particular fair use. Not that it's not important. Sometimes I say that copyright the field should be retitled Fair Use Studies. But I think there are other forms of IP that are going to be relevant. On our last panel, I'm especially interested in, because if we think about moral rights, the right of publicity, the softer IP rights connected with reputation and artistic style, I think AI technology is going to be a very serious challenge in those areas. And so we're trying to get out ahead as well as cover our bases. I don't want to take too much time because we have so much of substance to talk about. A couple of sort of housekeeping details. We will have a break at 10:25. This is an old building. There are bathrooms scattered around. You can find them. They do work if you are patient. And the other thing that I wanted to mention was that our first panel is going to go right up until that break. And then we have several in a row. So if everybody could come back from the break promptly, we can get started on that second part, okay? So to summarize the intro, I'm really happy everybody's here. I know many of you have come a long way. And even those of you who only came over the Bay Bridge fought a noble battle to get here. Maybe it's not the same as a 12-hour flight, but sometimes it feels like it. So I'm really grateful that people made the effort, and I hope that we have a good and productive day. So I'm actually going to allow panel one to get started. Dr. Howe will introduce everybody on the panel, but I should introduce her. She's our senior research fellow at BCLT, has taught patent law and IP law at Tsinghua University in Beijing, sometimes co-teaching with the Federal Circuit former Judge Randy Rader, many of you know. And she's been with us now several years running the Berkeley Antitrust and IP Competition Center, and she's been co-teaching the Human Creativity and AI course with me. Not just co-teaching, she conceived it and reduced it to practice. So she should be the sole inventor on the patent for that course. I'm just a tag along. And she will moderate this panel and hopefully during the day introduce some of her own research and thinking on AI, which has been revelatory to me. I think it's a very high-end contribution, and I've been very pleased to participate. So, Dr. Howe, let me turn over panel one to your hands.
Thank you so much, Rob. That's a very kind introduction. Again, my name is Yuan, and it's wonderful for me to be here today with you guys. I'm going to be the moderator of first panel, AI Challenges to Inventorship. I'm thinking because we have an audience with diverse background, and some of whom may not have been very familiar with patent law and AI challenges to inventorship. So maybe I'll just spend a few minutes, doing a very brief introduction of what we are talking about here today on this panel. So if you are patent experts, please just bear with me for a few minutes. To the very outset, what is so special about state-of-the-art AI today, SOTA AI, that merits our lengthy discussion of its challenges to various patent doctrines? It is special because in the first time in human history, we now have a tool that's capable of making significant contributions to the technological solution. And sometimes this contribution would be so significant that assuming the AI were a human being, no doubt she would have been found as an inventor. Thus, should we assign the honored position of inventorship or co-inventorship to the machine then? And in other situations, it may even become a question that even though there's human beings involved in this process, but the human being's contribution may not be sufficient to merit an inventorship under the traditional inventorship doctrine. So what do we do about those? So the way I see it, I call the latter situation inventorless inventions, shorthanded as II, which is a common challenge faced by multiple jurisdictions in the near future. So the way I see it, there are two basic scenarios of the II situation. The first scenario is illustrated with the very famous Dabos case. I'm sure several panelists will talk about that case. If you're not familiar with that case, it's this owner of AI system called Dabos, and the owner is Dr. Stephen Thaler, and he claimed that all the inventing work has been done by the AI, and he filed many patent applications around the world and claiming the AI is the sole inventor. And this generated a series of cases, both judicial cases and regulatory in some jurisdictions around the world. Despite this fame, I still think, personally, Dabos might belong to the easier wave of inventorship challenges. Because if we take the facts on its face value, there's really no human being involved in the process, because Dr. Thaler claimed that AI, Dabos, did, every bit of the job, which, we might touch on this later, but I don't think it's entirely consistent with my own understanding of the state of art AI. But leaving that aside, this is still an easy case, also because the regulatory branches and courts around the world, they were actually asked to just do a statutory interpretation of what constitutes inventorship based on their respective laws. But the harder case would be next wave. The legislature people might face the more daunting challenge that whether naming AI inventors would be consistent with deeper IP principles. So all of these are fantastic issues and also very challenging issues. But we have several experts from multiple jurisdictions here. Chris from US, and I'm sorry, Dr. Mammen, Chris Mammen's from US, and Mr. Chris Mauny from UK, Mr. Yong Shin from Korea, and also we are very privileged to have Ms. Nalini. Justin, can we maybe play it? Okay, hi, Nalini. Good morning. From USPD. I'm going to do a very brief introduction of our panelists, then we will start the discussion. The last housekeeping point is that we're going to divide the panel into two sessions. In the first half an hour or so, we're going to stay on the doctrinal level. So our panelists will inform each other and you guys about the status quo of their jurisdictions, what's going on there. Then I might, depending on the flow, I might push back with just one or two questions to facilitate the discussion. Then hopefully after this round, we still have like 20 minutes or so to go a little bit beyond the doctrinal level, diving into maybe some of the deeper normative principles, whether, through this lens, how this would inform people's understanding of the AI challenge to inventorship. So I'm going to do just a very brief introduction. Nalini is a senior legal advisor in the Office of Patent Legal Administration at the USPTO. In this position, she drafts rule packages, memoranda, and associated guidance on topics such as subject matter eligibility under 35 USC 101 and disclosure requirements under 112. She also coordinates the development and implementation of patent examination guidance related to artificial intelligence and other emerging technologies at the PTO. And sitting on my left-hand side is Dr. Chris Mammen. Between law school and entering law practice, Chris Mammen earned a doctorate in legal philosophy from Oxford. For the past 30 years, he has practiced IP litigation in the Bay Area, and on a recent sabbatical from practice, returned to Oxford as a visiting academic, where he convened a multidisciplinary working group on AI, IP, and creativity. And now, next speaker there is Mr. Chris Mauny. He is a patent litigation specialist based in San Francisco. He advises clients from a range of industries, including tech, life sciences, and sustainable technologies. Chris is licensed to practice law in England and Wales and registered as a foreign legal consultant with the State Bar of California. And last but not least, Mr. Yong Shin is an attorney at Jeep Yong law firm in Korea. He handles a wide variety of ICT and IP cases and also serves on the special committee for responding to artificial intelligence and legal tech at the Seoul Bar Association. All right, so I can't wait to start our US perspective. So each panelist firstly have 6 minutes or so to introduce the status quo in the respective jurisdictions. So, and after that, we might have a little discussion. Nalini, are you ready?
Yes, can you hear me?
Yes.
Awesome. Thank you, Dr. Ho. I will talk about the US from AI and inventorship from the US standpoint. So a quick overview of the inventorship laws in the US. If you look at the definitions, 35 USC 100 F and G, inventor or co-inventor or joint inventor are defined as an individual or individuals who invented the subject matter of the invention. 35 USC 101 says whoever invents or discovers, suggesting a natural person. And 35 USC 115, 116 require the patent application to include the name of the inventor or joint inventors, and also requires inventor or joint inventor to execute an oath or declaration. So the language of 35 USC 115 and 116 also refers to individual, himself, herself, person, etc., indicating that the inventor or joint inventors are natural persons. So we can conclude that the statute requires the naming of the natural persons who invented the claimed invention, irrespective of the contributions provided by advanced tools like AI. And there is also no section in the Patent Act that supports the position that inventions that are created by natural persons using specific tools like AI systems result in improper inventorship or are otherwise unpatentable. Now, the Federal Circuit has consistently made it clear that conception is the touchstone of inventorship. This is true in the case of joint inventorship context also, where a person who shares in the conception of a claimed invention is a joint inventor of the invention. In joint inventorship scenarios, the inventive entity for a particular application is based on some contribution to at least one of the claims made by each of the named joint inventors. Coming to USPTO practice, the USPTO generally presumes that the named inventor or joint inventors in the application are the actual inventor or joint inventor to be named on the patent. Now, Dr. Howe had been talking about this Dabas case. We encountered the issue of AI inventorship in 2020. In April 2020, the office received a couple of petitions in 2 patent applications where an AI system was named as the sole inventor. As you may be aware, the AI system was named Dabas. In the petition decisions, the office explained that under current US patent law, inventorship is limited to natural persons. And this case went all the way up to the Federal Circuit. And there, the Federal Circuit said, based on Supreme Court precedent, the court referred to the definition in 100F, etc., found that individual is a natural person unless Congress provided some indication otherwise. And in this case, Congress provided no such indication. The court concluded that the Patent Act supports the customary meaning that an individual is a human. And the court explained that it was not confronted with the question of whether inventions made by human beings with the assistance of AI are eligible for patent protection. The Supreme Court denied cert in this case. And following this case, we revised the manual of patent examining procedure. For those of you who are practicing before the USPTO, you know about this, in accordance with this tailored edition, and clarified that an inventor must be a natural person, and by extension, any joint inventor must be a natural person. And patent applications naming a machine as an inventor or joint inventor will be considered by the USPTO as having improper inventorship. And in Taylor, we dealt with AI as the sole inventor. Generally, inventors use AI systems in different capacities and different points during the invention process to arrive at their inventions. So we had to address the situation where AI is used by natural persons in the invention creation process. While the Taylor case was going through the court system, USPTO conducted many stakeholder engagement activities like requesting RFCs, requesting public comments. We also held public listening sessions on this issue. And following this, we issued the inventorship guidance for AI-assisted inventions February last year. The key takeaways from the guidance were that AI-assisted inventions are not categorically unpatentable. We provided a framework for determining inventorship based on the Federal Circuit decision in Panu v. IOLAB 1997 case to determine whether a human's contribution is sufficient for proper inventorship. Practically, as AI is used during in different aspects or stages of the invention creation process by the inventors, we provided some guiding principles to help the practitioners, etc., understand. like how to use that. Based on the statutory language of 35 USC 161 and 171, the guidance applies to plant and design patents and patent applications also. The guidance further discussed potential impact on areas of patent prosecution, like foreign priority claims, how you deal with that, what you can expect from oath declaration practice, duty to disclose, Rule 56, etc. And please note that this guidance is currently under review for alignment with the administration priorities and policies. So keep an eye out, like if there is any changes. And for your for your reference, the MPP sections are given here, and the link to the Federal Register notice that I just talked about is also provided. Back to you, Dr. Howe.
Thank you so much, Nalini. I know really fantastic, but I know the guidance is currently under review. But are you allowed to briefly just introduce the 5 guiding principles or not? If not, I'm gonna skip that.
Yeah, so the 5 guiding principles generally talk about like various scenarios, like they were more permissive in that they allow like for humans to be named as inventors in different scenarios, like building the underlying AI systems or finding solutions to problems, and fine-tuning the output so that they arrive at the invention, all these things. But in essence, like they provide more guidance, like as the Federal Register notice has more details about those guiding principles.
Oh, sure. Yeah. Thank you. If I can just ask one more question, is that I think it's very important that in this guidance, you said that AI-assisted inventions are not categorically unpatentable for improper inventorship, because the way I observe it, not to steal our later panelists' thunder, is that we are actually witnessing a lot of case studies of AI-assisted inventions already during the past 3 or 4 years. And 2 typical industry sectors would be materials science, material research, and drug discovery. So categorically, if excluding all these AI-assisted inventions outside the patent law protection, to me, sounds not very practical, at least. But regarding the thing is that, again, not to steal thunder, is from later panelists, some of now speakers like Professor Artie Wright did some amazing research regarding case studies of AI-assisted drug discovery, for example, but found that maybe many of those applications, even though there was substantial AI involvement, but because of the unpredictability of the law right now, so not too many people want to review AI's role in the patent applications. So from the perspective of a senior patent examiner in the United States, do you think the patent applicants in the future, they should disclose that? Or how do you evaluate the inventorship requirement? Can you give us some basic idea there?
Yeah, so we do not impose any additional duties to disclose the use of AI tools. We already have existing rules and policies for all types of patent applications, and AI-assisted inventions are no different. So to give you an example, like consider some of the scenarios. If you look at the inventorship scenario, AI, we consider AI as just another tool, like a microprocessor or a sequencer that's used by natural persons in the conception of the claimed invention.
Okay.
A patent application needs to identify only human inventors in the application data sheet. There is generally no additional duty to disclose information about how these inventors used AI in the invention process, unless it's requested by the USPTO during examination, which I'll go over in a bit.
Right.
If the AI tool or its use is material to patentability, you may need to disclose the required information pursuant to existing rules, like, for example, duty to disclose in Rule 56. Some tips to determine inventorship are given in MPP 2004, where the practitioners can decide who the actual inventors of the application are. Also, if a claimed invention is itself related to a particular AI system, you may have to comply with the disclosure requirements under 35 USC 112, and that one you are already aware. Now, coming to the second later part, like once you disclosed, once you file the patent application, coming to examiners evaluating inventorship, typically examiners do not make inquiries regarding inventorship. The USPTO presumes that the named inventors in the patent application or the patent are actual inventors. That is, the information the practitioners provide to us in the application data sheet or the oath declarations, we presume that they are the actual inventors. Because of this presumption, the rejections under 35 USC 101 or 115 for improper inventorship are usually very rare, and we are seeing the same trend. We don't see any heightened trend with regards to AI-related inventions. But when I said I'll discuss it later, if there is evidence to the contrary, like examiner finds some evidence and the examiner makes a rejection under 101 or 115 for improper inventorship, now the applicant can come with appropriate evidence to traverse that rejection. Just like you traverse other statutory rejections, you will have to provide evidence to traverse the rejections. Here also, there is no change in practice. The USPTO does not prescribe a specific format in which evidence is presented, as long as the objective evidence is supported by actual proof. So we do not have any changes in practice or anything to deal specifically to disclose use of AI in arriving at your invention.
Thank you for the nuanced explanation, Nalini. That was very helpful. I think we will just maybe keep it to the end. We will have 10 minutes or so to the end of panel 1 for our audience to have Q&A, if that's okay with you. So for now, we'll just proceed with Chris Mauny, and who will kindly introduce the UK and EU practice on AI in challenge to inventorship for us. Chris?
Thanks very much. Can I get my slides up on the screen? Or?
It's coming.
Great. Thanks. Well, as indicated, I'm going to try to give some highlights of the position in Europe. Everybody talks about Europe as if it's a homogeneous block, which for patent law is partly true in some respects and very much untrue in others. So let me start by getting into... okay, this is a slightly different deck, but let me start by getting into the position from the European Patent Convention. So this is the international treaty that effectively serves as the legislative basis for the operation of the European Patent Office and for much of substantive patent law among the European Patent Convention states. And what you'll see is Article 61 gives the right to a European patent to the inventor or to a successor in title. So that's the foundational principle of the origin of the right to a patent. Now, in the Dabus case, the issue was, as already indicated, whether the scope of the term inventor could include an AI system that was said to have done all of the inventing activity. And when this case was heard by the legal board of the EPO, they stated very clearly that an inventor, a machine is not an inventor within the meaning of the EPC. And we'll unpack that slightly on the next slide, but it's a very clear statement that quotation is from the head note. So that's basically summary, no machines are inventors. And to analyse that position, they turned to Article 61 and identified 3 functions that are embodied within that short text. And I think that the second and the third are really where the focus of the case is, but fundamentally it all flows from the first function, which is that unless you fulfill the conditions of Article 61, there is no right to a patent. So you've got to fulfill those conditions for there to be anything to successfully file. And the analysis, I've obviously pulled out some very short passages from what is quite a long decision, but the analysis is really very simple. The interpretation of the term inventor means a person with legal capacity. That's its ordinary meaning, and there's no reason to think that the legislation should bear any other meaning than the ordinary meaning. So a person with legal capacity has to be named as an inventor. If you don't have that, there's no right to the invention, and there's no way for that right, if it existed, to flow to another person, such as Dr. Thaler in this case. So the immediate, more practical question is, well, if Dr. Thaler had approached the matter in another way, or in another less extreme example, could a patent that is derived from an AI inventing activity be filed and successfully designate an inventor? The EPO did address this point. The argument was made that if they reached the conclusion that they did, that would treat certain classes of potential inventors or people deriving their rights from inventors unfairly. And I guess this probably harked back to things like the Paris Convention, equal treatment, etc. And the board simply said they're not aware of any case law that would prevent the user or owner of a device involved in inventive activity to designate themselves. So they don't get into detail as to the level of involvement, what kind of right that person, I mean, they use the word owner, but in detail, what kind of right that person would have as regards the inventing machine, let's call it. But they acknowledge that, in principle, a patent that has derived from activity that involved an AI system could be patentable by reason of having an inventor who is a legal person. In the UK, this case went, or the corresponding case went all the way to the Supreme Court. And I'm not going to go through the whole of this slide, but the pertinent thing is at the bottom. An inventor within the meaning of the 1977 Act, which implements the European Patent Convention, must be a natural person, and Dabus is not a person at all, never mind a natural one. So, same conclusion after 3 layers of litigation. What about that more practical, more real situation? The court dealt with this slightly differently to the EPO. They said that this is more than a formal objection. It goes to the heart of the system. So they took the view that it's not merely about who you name on the form. In principle, it is actually about having a human person. And that's subtly different from how the EPO expressed themselves, because the EPO effectively said, if you have an owner or something involved, then you may be okay. I think what one needs to bear in mind, however, is the practicalities of how things work in Europe, which we'll turn to in a moment, mean that this is unlikely to be challenged in most cases. If a human inventor is named and said to be the inventor, that is likely to get through. But what's particularly interesting is that in September, another of Dr. Thaler's applications was analysed by a first instance appellate judge having come from the UK Patent Office, and it was rejected because although Dr. Thaler attempted to name himself as the inventor, the history both of that application and more generally indicated that he himself did not believe that he was the inventor. So I'm not going to go through all of that, but effectively he had changed his position both on the suite of inventions that came from Dabus that had all been filed at the same time, and on this specific application, he had changed his position from I am not the inventor because I did not contribute to I am the inventor because I'm a human, as it were. And when this was challenged in these proceedings, the explanation was that he had changed his position because his understanding of the law had changed following the Supreme Court decision. But the Patent Office and then the court held that this wasn't persuasive because what he'd actually said was factually, I didn't do anything. I switched the machine on and the invention came out at the end. I made no contribution. And so in that case, it wasn't good enough for him to simply now say, but I am naming myself as the inventor. It was contradicted by his statements of fact about how the invention had come about. And I'm going to pause there.
Thank you, Chris. It was very informative. I do have a lot of questions, though I might just ask one of them because this is very important for me. Is that it seems to me that in either UK or Europe, there's no more specific definition of what constitutes inventorship. In the first place, leaving aside AI, but in a traditional sense, except the situation, it has to be a natural person, right? If we compare it with the U.S. practice, in the U.S., everybody knows the conception is the cornerstone of inventorship, and to constitute conception, there's a series of case law in the, basically, if I could paraphrase it, the formation of a complete and settled inventive idea in the mind of the inventor, and if you look at China, whoever makes inventive contribution to substantive feature of the claims would be considered as the inventor. So those are all requirements on top of the natural person. Mm-hmm. But it's a little bit surprising to me that, UK and EU, why is that?
Well, there's two parts of the answer to that. The first is that the issue of inventorship and ownership is not dealt with at European level. So the EPC does not provide for a definition, and the EPO does not deal with the matter, and nor indeed does the UPC. So it is addressed at national law level. In the UK, the case law is mostly derived from issues of entitlement, i.e., competing parties saying you filed an invention that was mine or that of which I was a co-inventor. And the standard is that the inventor must be the actual devisor of the invention, or one of the actual devisors. And because of the nature of the case law, where it's derived principally from these kind of co-inventorship or inventorship dispute type cases, there isn't that much explanation of, if you will, what it means to be the actual devisor, in the sense of, do you have to have made a contribution greater than a certain threshold? The case law is to the effect that if you have contributed to the inventive concept, then you are one of the actual devisors. But it hasn't analysed in great detail the degree of contribution to be an actual devisor. As regards other countries, they have their own standards, and I can't go through those now.
Okay, that's fair.
Perhaps I can just add one more
Sure.
comment, which
No
is
problem.
that because of, I'm sorry, I can't, because I had a slide about this, but the issue of inventorship only arises in the context of those type of entitlement disputes. So inventorship can't be used as a freestanding challenge to a patent's validity unless the person making that challenge says they were entitled. And that's one of the reasons why there's this only very limited amount of case law. But it also means that a Davos-like situation, or again, a more realistic one where there is a person named, if there's a suspicion that, in fact, all of the inventive work was done by an AI machine and you're a defendant being sued on that patent, for example, there's no ready way of defending oneself by saying the inventorship is wrong, that this is a misstatement of inventorship, etc. That's simply not a ground for challenging the validity of the patent. And so not only is there limited case law, but it's also of limited utility in patent litigation to start looking at inventorship.
Oh, it's very interesting. I mean, my understanding that the patent entitlement cases in UK are somewhat similar maybe to the patent interference cases in the US, but not completely because it's less strict. I'm sorry, just a quick...
I don't understand the full ins and outs of inferences, but in broad sense, yes, it's about typically a situation where there's been a collaboration and one party to that collaboration has filed a patent and another party says, I should be either the owner or a co-owner of that patent.
Okay, I mean, because of the time, we'll just continue that discussion offline. But fascinating introduction. Mr. Shin, would you please introduce the practice of Korea to us?
Yeah, thank you. Change the slides. Yeah, I introduced the Korean perspective on AI inventorship. Yeah. And I would like to introduce firstly the Korean Intellectual Property Office's position, and it's similar to the other jurisdiction, and no AI inventorship is admitted, and also the Korean patent office and the court does not currently recognize AI as an inventor. For the on the legal basis, the Korean Patent Act is interpreted to limit inventorship to natural persons, and there has been no official institutional discussion on AI inventorship since the Davos case. And Davos case is adjudicated in Korea, and the Seoul High Court decides there is no AI inventorship is not admitted, and the case is pending in the Supreme Court. Yeah. And the Korean Patent Act indicates that the inventor is only human, and the Article 33 in Korean Patent Act that any person who has made an invention or his or her successor shall be entitled to a patent. Yeah. In the legal interpretation, the term person is consistently interpreted by KIPO, the patent office, and Korean courts to mean a natural person only. And the Korea follows the civil law system, so the court and the government should follow the statute of the act. And I consulted the senior official in KIPO, the patent office. So KIPO is now studying the degree of human contribution required. And yeah, if a human using AI does not make a significant contribution to the invention conception, the person also cannot be an inventor, is a reference from the Panu case. And the research goal is to establish standards for the level of human contribution needed for recognition in AI-assisted inventions. So the study of the Korean government is an annual timeline. So research results are expected early next year. So I'd like to share the results of the research to you soon. And in addition, as I said before, the patentability gap would arises if neither the human nor the AI qualifies as an inventor. So it seems to result in that the invention cannot be patented. If the patent, the application is disclosed, the invention may enter the public domain if it was not disclosed. If it were disclosed during the patent application process, and if not disclosed, it would be in the patentability gap would arise, or later, independent human inventor could still obtain a valid patent for the same invention. Yeah. And so, in the perspective of practical examination, it is crucial. I think it is crucial to determine if a valid inventor exists prior to disclosure. And it is the other issue is the examination of AI-assisted patent, and it's difficult for patent examiners to distinguish human versus AI contributions. So examiners often cannot separate the human's input from the AI's output based on the application alone. So we can think the solution, the temporary solution, and ideas from the other act, the Framework Act on Artificial Intelligence. It will be it was enacted in Korea or the EU, and it will be activated in the next January in Korea. And in the Framework Act on Artificial Intelligence, imposes the transparency obligations on AI providers. It requires indicating when an app has been generated by Gen AI, and the method of indication is not confirmed in the law, so the invisible watermarking can be possible, and this may help examiners distinguish the human's creative input during examination if the human use the AI of the platforms of such obligations. And the next is the other. So, is the do I proceed or the remaining is the other issues?
Sorry.
Yeah.
Do you what?
So do I proceed or? Yeah.
On in time. Oh, sure. Maybe we'll just stop here for a little while, and because of the time limit. But very interesting. Maybe I can ask some question to clarify just one or two points, because that's very informative introduction, Yong. But I noticed there are like 2 points very important My understanding is that the 2 points required, 2 points out of many required by this framework AI Act. One is that the so-called patentability gap, you said, maybe it's similar to the inventorless inventions I mentioned earlier. You said that it has to be, if it's disclosed, it enters public domain. Was that required by the AI Act as well? Is that a binding act, or is just being proposed? And was the act passed already? The AI Act?
It's kind of the patent issue. Yeah, Patent Act. Yeah.
Oh, okay. So maybe my understanding was wrong. The patentability gap kind of inventions entering public domain, that was not required by the act. That was a practice.
Yeah. It's hard to say
A position by the IP office, or
in the due to the IP law and the Patent Act, if there's something of the application of the patent is disclosed in any way, so the patentability is lost due to the Patent Act. So. So
Becomes prior art.
prior art,
Right.
yeah.
Okay, yeah. But that act has been passed. Is binding, or it's just still being discussed? Next year.
No, the disclosure seems to be not discussed yet because it's the doctrine or dogmatic. It's the principle of Patent Act. So the research now on process is just writing whether the person using the AI can be an inventor.
Right.
Yeah. With regard to the significant contribution. Yeah.
Okay. Okay. Thank you so much. Let's move on for now because we have many fascinating stuff to talk. So this is for Dr. Mammen, Chris. I know you have given a lot of thoughts to creativity and in AI, so in intersection, the interplay between them. So maybe you could spend 6 minutes or so, introduce some of your thoughts, just looking through this lens.
Sure, yes,
Okay,
happy to. And if we could pull up the next set of slides, that would be great as well. And while the slides are being pulled up on the screen, the discussion here is part of the output of this sabbatical project that Yuan mentioned. We had a multidisciplinary group conduct last year, and really it breaks down into 3 principles. We've talked so far about this doctrinal question of IP requires humans. And as we heard Nalini mention, in the US, this goes all the way back to our constitutional provisions as well as the Patent Act. We've also heard from Chris and from Mr. Shin about how those play out in Europe and Korea as well. The second point, which is sort of a departure into more theoretical questions, is the observation that beyond the fact that the statutes and the positive law is written to require a human, to however inventor is defined, it's been interpreted to require a human as a matter of legal interpretation. Going a step below that and saying, well, why is that? And what we see scattered throughout the case law is discussion about this idea of creative genius and ingenuity, and sometimes it's the flash of genius, or other times it's a series of steps of diligent research that are not obvious. It's systemic experimentation, but it's not just brute forcing your way through a whole bunch of permutations. And so we use that as our pivot from the written doctrine to a question of creativity. The hook for this really shows up, I think, in as much in the law of non-obviousness as it does in the doctrinal requirements of an inventor being human. And that creates some interesting tensions that are perhaps open for future explanation about the fact that inventor as human is one place in the law and creativity is another place in the law. How do those connect up? And then the other point that I'll introduce and then move forward on is that this idea of creativity is measured against that of a person of ordinary skill in the art, a community standard. And I'm going to come back to this idea of a community standard as being important to creativity. So let's go to the third of our three questions. What is creativity? And this was really a wonderful part for me to learn in this sabbatical project because we had philosophers and physicists and neuroscientists and computer scientists all in the room together talking about this. And we did a really deep dive in what the existing scholarship says about creativity. And the two main points shown on this slide are the two key things that are really well covered in the literature. If we talk about creativity of artifacts, things, sometimes that's referred to as external creativity, and there's some well-established tests saying if something's new and valuable, and sometimes if it's surprising, then we can say this thing, this artwork or this document or this musical composition is creative, and we can talk about it as an object. But we also talk about psychological aspects of creativity. A person engages in creative acts or is creative, and there's a body of neuroscience around that. And to the best of our understanding from this working group, there's the very interesting dance that goes on between our convergent thinking, our task positive thinking, when we're focused and working on a problem, and then an idea comes to us in the shower, or we sleep on it overnight and something comes out. That's divergent thinking, default mode network, what our brain is doing when we're not focusing on a task. And then the salience network is the part of our brain that says, aha, that piece is relevant to this other thing you were working on. And it's really a back and forth between all three of these that produces creativity. You can't brute force your way to creativity through just convergent thinking. It's not something that just daydreaming alone is going to come up with. And so there's an important aspect to all three of these. And then what our working group added to that is that underlying all of this is a social or community aspect of judging creativity. If something's new, it depends on what else exists or what the relevant community is. Sometimes, we talk about a child drawing a picture of their cat as being creative, even though millions of children have drawn similar pictures of cats. But there's something creative about that exercise. So it's looking at a narrower community. Valuable part of the aspect of the external artifact measure of creativity is a social value. And salience, even the psychological aspects, has some aspect of social relevance. And these are some figures that are from other sources. They're in our white paper. If you look at all of the words that are used in the dark circle in the Venn diagram, they're all sort of social judgments and reflect that this is part of how we talk about creativity. And similarly, the chart on the other side is saying, look, if something is not new at all, if it's really familiar, it's not going to excite us. It's not going to create that kind of response. If you move away and it's kind of new, it'll go up the curve until it peaks at some point, and then it becomes too avant-garde, too far out there, and then we don't like it. And those are reflective of social judgments as well. So how do we apply this framework of creativity to patent law? Well, clearly, we have to have an artifact. There's a reduction to practice of the invention, or a constructive reduction to practice in the patent application. And new, valuable, and surprising tracks very conveniently with new, useful, and non-obvious. The internal creativity, I showed you that either the flash of genius or the methodical but non-obvious diligent research is part of what's required. That psychological aspect is also required as part of the creativity for patent law. And then the social factors come into play in terms of our measure of what is the level of skill in the relevant art at the time of the invention. So it maps very nicely to this traditional account of these three aspects of creativity. If we then turn to generative AI, the external aspect, which has driven a lot of our conversations, it's kind of the same. Stuff that comes out of generative AI clearly is capable of being new and valuable, maybe because generative AI is focused at, coming up with high probability outputs. It's maybe a little less prevalent that it's surprising. But that's also, sort of a soft factor for the artifacts. Task focus, the convergent aspect of internal thinking, may be very analogous to humans. But this dance between convergent thinking, divergent thinking, and the salience network is not something that anybody in our working group was persuaded could be mapped to what goes on with generative AI algorithms. And then the social factors are kind of all over the map. Some stuff humans react as if it's human-made. It's comfortably familiar. Other things, you kind of hit that uncanny valley. Things are a little too weird. But that social judgment is also present. And so, that I invite you to consider as a framework of thinking why human creativity, and in particular the psychological aspect, is really a justification for this human inventor requirement. And there's a QR code if anybody wants to pull the white paper.
Very interesting. I found it fascinating that actually much of Dr. Mammen's research overlaps with the course Rob and I co-teach at UC Berkeley here. Actually, it's interesting that for the first two classes of this course, we assign a lot of readings on creativity research. And Sasmita is one of our students. I hope you guys forgive us for doing that. But I am kind of obsessed with, I think there's a lot of good stuff as Chris just showed us. And, I'm sure just the flavor of it. He did a lot of research on this. So one point I do want to highlight here with the limited time is that I find the difference between product-based or in Chris's words, the artifact-based definition of creativity, which means regardless of the creative process, as long as the output is new, surprising, and valuable, just to quote Bowden, that's, we find creativity there. But there's another school of thought saying that, no, we don't, that's not the only thing we care about. We care about the process as well. The process is very humanistic. I find, as it has to be a lot of, sparkles, and also the creative process as fulfilling our, inner vision as a creative individual. So anyway, in a nutshell, I find this kind of differentiation might also resonate with some deeper justifications of intellectual property as a system. If I could, refer to Professor Murge's, I think it's a seminal book, a 2011 book, Justifying IP. So my question, sorry, for all of you, before we quick move to the audience, is that, Chris, do you think whether your or people's deeper beliefs about IP justifications might affect how they take these AI challenges to inventorship?
Short answer is yes, and maybe we can take the slides down so Nalini can rejoin us here. Great. And I think so very much. I think that, in the many conversations I've had with people around this, quite often the justifications are articulated in terms of our IP system exists to support national economic and industrial policy, or it exists to support what Aristotle would have called eudaimonia, the pursuit of a good life, of sort of humanistic well-being. And a lot of times how people break on that question influences how they work backwards to answer the rest of the analysis. Utilitarianism, I think, a lot of times gets distilled to just an economic analysis, but take writ more broadly, a utilitarian justification could include both sort of economic well-being as well as some of these other inchoate types of well-being. And so how you approach those fundamental questions really does influence how you think about the whole analysis.
Beautiful. So we have like 3 minutes before we move to the audience questions. So the rest of our 3 panelists, in your jurisdiction, so just a very quick question, sort of oversimplifying it, but have to do that, is there a mainstream IP philosophy in your jurisdiction, and how do you think this would affect, how, the courts, they take the challenge? Chris?
I think there is, but it does vary somewhat. And what I mean by that is that more traditionally, I think the focus in England has been rather economic in outlook. But the influence of European law, and I use that term in a very loose sense, meaning both the EPC and European Union law, has changed that slightly. And if you look at European jurisdiction, continental European jurisdictions with a very broad brush, there is somewhat more focus on the sort of the rights of the author, talking about copyright here, but moral rights, that kind of idea is, as a generality, more important. So I think when you sort of bundle that all together and look at AI and IP broadly, it's a pretty open question as to where things might go. At the moment, the focus in England, at least, is more on AI and copyright and dealing with that than AI and patents, because I think that's thought to be the more pressing issue. But it will need to be addressed, and I think it will probably be looked at economically. And issues like if one accepts that AI can be some kind of inventor or co-inventor, which would require a change of the law, how would you allocate that? Because ultimately the AI isn't going to be the beneficiary of that. It's going to be the owner, whatever that means, the user, the trainer, the provider. There's a whole range of options which have different economic impacts as to how you effectively designate or deem the inventorship if you accord it to an AI system.
Wonderful. Okay. Yong, Korea.
Yeah, I think the Korean IP approach is aligned with the global standard, global legal framework, but intends to place greater emphasis on national welfare. And so I think, and AI inventorship in granting is seem to be 2 aspects, the pros and cons. And someone said, and many people said it drives the technology, the progress. Yeah, because the AI internship makes the developers, AI developers, to make the greater good performance of AI. And other people said if AI were granted inventorship, the AI owner would hold their patent rights and get some benefits of the patent. So it may hinder the innovation because the employee does not don't get the benefits of the AI, the inventing. So it may hinder the progress or innovation of the AI inventing.
Okay, thank you. Nalini, do you want to quickly, just 1 or 2 sentences?
Yeah, sure. I like you have heard about the U.S. perspective from Dr. Mammen, right? So this inventorship requirement, naming the inventors in the applications, all this, these are some of the characteristics that are very unique to U.S. patent law, not generally shared by other countries. So I see it as if you look at Article 1, Section 8, like Dr. Mammen talked about. So you're trying to promote the progress of useful arts, sciences and useful arts at the same time, reward human ingenuity, right? So I think it's both these aspects come into play when we are looking at it from the US perspective.
Thank you. It's very interesting. So we have about maybe 10 minutes, 9 minutes or so to have some Q&A from the audience. Sorry, I wasn't that good at controlling the time, but I do my best. Any questions from our audience? Oh, I think Lisa had first. So maybe there's a microphone.
Hi, I'm Lisa Willett from Stanford. So thanks for a great panel. And this follows up on the questions about how this connects to the justification for IP. And I find a lot of the discussion about, both how countries have kind of doctrinally thought about this question and some of the scholarship confusing in that, at least from a U.S. utilitarian or at least welfarist perspective, it seems largely not focused on the key question of how does AI's role in the inventive process affect the question of whether this is the kind of invention that we, from a social welfare perspective, want to have patent protection on, and whether the role of the patent in incentivizing the invention and its commercialization is worth the cost that invention has for society. So, and I realize you have been talking about this, but just more crisply, why, do you think that should be the way that, from a U.S. perspective, we're thinking about it, at least, or from other countries' perspective? And if so, why does the doctrine seem more muddled than that?
Great question. And, I'm inclined to agree with the premise that in some sense it's like a multivariable equation. And if we can solve for one of those variables, then it becomes easier to solve the equation for the other variable. And I'm afraid what I'm doing by suggesting this dichotomy between the industrial policy and the humanistic aspect is to unsolve for that first variable, making it so we're dealing with the practical questions of what should the policy be, even as we're also caught up in the swirl of what are the underlying policy justifications. But I think it's important to have that conversation and talk about both parts of that at the same time, as opposed to postulating one of them away in order to make it an easier question to answer.
I think.
Chris.
So from my perspective, in English law, we always bear in mind that patents are an exception to the basic rule that monopolies are abhorred, and that needs to be thought about here if technology flows in a certain direction. I think Mr. Shin was alluding to this a moment ago, that the sort of prospect that potentially a small number of actors could suddenly hugely dominate across many fields by churning out thousands of inventions is not something which the patent system was set up to endorse, in my view, and I don't think that most English patent lawyers would think it was either. How one actually deals with that is really challenging, but I think it is an issue that will need to be addressed if that is how things move.
So it's the role is related to policy and the benefits of the patent system should be distributed with justice. So yeah, and so I think it needs to be careful to grant the AI inventorships because it may result in the big impact on the economy, related to the technology industry. So, as I said before, the AI inventorship may good or bad impact. There are two aspects. So we need to expect the impact of the system, legal system, and so we need to we need to be careful. Yeah, that's all.
So I think the lady on the right, she raised her hand second. Sorry.
Just speaking as an IP licensing lawyer, has anybody ever raised the question of whether it really is an invention or not, if it's created by an AI algorithm? I mean, has that ever been thought about deeply? It just seems like there's an assumption that, yes, it's an invention because it's new.
Just to clarify the question a little bit, so you mean the AI contributed to the invention in such a significant way that if it were a human being, she would have been found as an inventor, right? The conception, U.S. context, is that what you mean? Or
I don't know enough to ask the question well.
Okay.
Let me try again.
No, that's a good question, sorry.
Let's suppose that an AI machine operating with an algorithm creates a new result of some sort. Is it a foregone conclusion that that constitutes an invention, even though it may fulfill the other criteria of what is defined as an invention? So I'm thinking not so much about the inventor as the invention piece of that. Is it an invention? Has anyone ever debated that? That's my question.
Okay. Our panelists first. Yeah.
I'm happy to jump in, but it also seems like it may be a good question for Nalini.
Yeah. So what we do is, I can tell from the patent office perspective. So what we do is, once the application comes in, once a patent application comes in, we evaluate that application on the basis of the statutory provisions, right? Whether it satisfies 35 U.S.C. 101, is there prior art, where you talk about whether even if it is an invention or not, that would play into that. Like, did someone else invent this piece before, right? 102 and 103, and then is it sufficiently described? So if you look at the patent statute, it says like the person is entitled to a patent unless the patent office finds some reason why they should not give the patent, right? So I'll start the conversation with that, and I'll let the other panelists chime in.
Maybe just 1 minute. I'm really sorry, but because of the time, I'm just quickly chiming.
I don't think there's a legislative basis in my law for distinguishing patents depending on how the subject matter was derived. If we ignore the inventorship issue, I don't see where you would get a basis for distinguishing that. It's an objective assessment of whether the claimed invention is, let's say, non-obvious, to adopt a slightly different phrase, from the state of the art.
I'm really sorry. I have to stop here. I know we still have questions, but luckily you guys can grab our panelists while having coffee. We'll come back within like maybe 15 minutes for panel 2. And thank you so much, our wonderful panelists. Nalini, thank you.
Thank you, Yuan, for hosting our panel.
Oh, thank you.